Imagine this. A parent spends thousands of dollars setting up a trust, thinking they're protecting their family. But when they pass away, their children stop speaking, the trust gets dragged into court, and what was meant to preserve family harmony turns into years of fighting and legal fees. I'm Guy DiMartino, an Indiana estate planning and probate attorney, and I've seen this story play out too many times. Here's the truth. Most trust contests don't happen because someone was trying to be unfair. They happen because something was left unclear, poorly drafted, or never fully explained. In this video, I'm going to show you why trusts are contested and what you can do right now to make sure your plan actually works, protecting your assets, and most of all, your family relationships. The number one reasons trusts are contested is lack of communication. The biggest reasons family fight over trusts is that nobody ever sat down and talked to them. A trust can be perfectly legal on paper, but if your kids don't understand why things are set up the way they are, they'll fill in the blanks with resentment and suspicion. I've had cases where one child was named trustee and the others weren't, and that alone started a long feud. When I asked, did your parents ever explain their decision? The answer was almost always no. That's why one of the biggest ways to prevent trust contests is to communicate with the beneficiaries while you're still alive. You don't need to disclose every dollar, but explaining why decisions were made builds an understanding, and understanding many times will prevent a lawsuit. That conversation is often worth more than the trust documents themselves. The next reason trusts get contested is because they were drafted using one-size-fits-all template. Every family is unique. What works for a simple family in one state may not work for a blended family here in Indiana. A trust that's poorly worded can cause huge legal uncertainty. For example, the trust doesn't clearly define what equal shares means. Are we talking about equal dollars or equal assets? The trust leaves out key successor trustee provisions, or worse, it names a trustee who's passed away or is incapable of serving. When the language is vague or outdated, you're leaving the door wide open for a court battle. So the lesson here, don't rely on cookie-cutter trust forms or online templates. Work with somebody who understands Indiana trust code, probate law, and local court procedures. A few $100s saved up front can cost your family tens of thousands of dollars later on. Now let's talk about one of the most emotionally charged reasons trusts are contested, and that is claims of undue influence or lack of capacity. What does that mean? Let's sort that out. Here's how it usually happens. Late in someone's life, someone becomes dependent on one child, or a caregiver, or a new friend. That person starts helping with bills, doctor visits, and daily life, and then one day, a new trust appears, leaving everything to the caregiver. The other children find out after the parent's death, and now they believe that sibling or caregiver manipulated the parent. Indiana law allows a trust to be challenged if there's evidence that the person who made it didn't have the right mental capacity or was improperly influenced by somebody who had a fiduciary or close relationship with them. To prevent that, have your trust signed in an independent attorney's office with independent witnesses. Document your mental clarity at the time. Sometimes even a short video clip can help. Avoid making drastic last-minute changes to your plan unless they are absolutely necessary. A well-documented, consistent estate plan is one of the best defense against these kind of claims. The next issue we see is mismanagement or lack of transparency by the trustee. Even a solid trust, with the best language, with the nicest paper and binder, can fall apart if the trustee doesn't act properly. Trustees have legal duties under Indiana law to account, to act impartially, and to follow the terms of the trust. Most trust disputes start because the trustee didn't keep everyone informed. When people are not informed, they start to get suspicious when they don't see regular accountings, when assets aren't distributed on time, or the trustee starts mixing together their personal funds and trust funds. The easiest way to avoid that is pick a trustee who's well organized, fair, and trustworthy, not just the oldest child or the one who leaves closest to you. And if your trust has complicated assets, consider naming a corporate or professional trustee. They know the rules and they can take the family emotion out of the equation. Transparency prevents conflict. A good trustee can protect your legacy instead of becoming the reason for a lawsuit. Another reason that we see trusts get contested are changing family dynamics. See, families change, but the trust never does. New marriages, stepchildren, divorces, grandchildren, life evolves, and your trust needs to evolve with it. It's not a set it and forget it type of instrument. If you set your trust up 15 years ago and you never had it reviewed, chances are it may no longer fit your family's reality. Maybe one child now struggles with addiction. Maybe you have a new grandchild. Maybe you have a grandchild with a special need that you want to take care of. Maybe one of your child's or spouse, is not exactly the person that you would choose to inherit your assets. So you either want to leave them out or you want to have somebody else manage their money to protect them from themselves. A regular trust review every 3 to 5 years is the best insurance policy against a future conflict. Your trust should reflect your values today, not what life looked like a decade or 2 decades ago. Now I'm going to give you a bonus tip. Don't hide the ball. If you're serious about preventing disputes, transparency is your best weapon. You don't have to reveal account balances to your beneficiaries, but you should make sure your family knows. Number 1, that a trust exists. Number 2, who the trustee will be, and if there's some contention, why you chose that person or that organization. And number 3, where your documents are located. The worst time for your family to discover your estate plan is after you're gone. So let's recap. Trusts are most often contested because of number 1, lack of communication. Number 2, poor drafting or outdated terms. Number 3, claims of undue influence or incapacity. Number 4, mismanagement by the trustee. And number 5, changing family dynamics. The good news is that every one of these can be prevented with clear planning, regular updates, and honest communication. If you already have a trust and you're not sure if it's bulletproof, or if you're creating one and you want to make sure it stands up in court, that's exactly what we help families with every day. Visit GuyDiMartino.com or call our office to schedule a consultation and protect your legacy. And if you found this helpful, hit like or subscribe and watch the next video. 5 ways to properly fund your Indiana Living Trust, because even a perfect trust doesn't work unless it's properly funded. I'm Guy DiMartino. Thanks for watching, and I'll see you in the next video. Have a great day.